Okay, it's time to start. Thank you for attending today's webinar. Today, we are going to talk about integrating AI-powered solutions into patent practice. We have two guest speakers that they are very expert in this field. And then first, uh, speaker is Roger Han, is an attorney and patent attorney, and then he's a founder of the Abigail AI. He may be introduce himself more detail later. And second speaker is Alex Levin, a co-founder and CIPO Pioneer IP, and then I'm going to talk. Okay, so schedule will be like that. So for 15 minutes to Roger will talk about integrating AI solution into patent prosecution and Abigail AI demo. And followed by the Alex is a Pioneer IP, is an infringement detection AI solution demo. And then I will talk about AI solution landscape integrating AI across patent workflow. And then we have a Q&A session. Okay, so without any delay, so Roger, could you please share your slide and start?
Yeah, sure. So I'll just start with a quick introduction. I'm a 26-year veteran in patent prosecution. I started working in patent automation and data science for since about 2018. So I've implemented several solutions and moved over to AI, I guess machine learning or AI as we now call it. And the three things that I'm going to lay out in the roadmap today, which I think we need to flag as professionals in this industry, is first hallucination. That is a story that's coming out almost every day. So with the latest in federal court from Sullivan Cromwell, a white glove firm, which ironically talks a lot about AI safety, um, and some egg on their face over the last few days. The second topic I want to talk about is privilege and confidentiality with LLMs. And this is a landmine that's just not talked enough about. Recently, we had the Hepner case in New York City, which poses a massive risk, I think, to many practitioners. The third topic is benchmarks. So we have a lot of vendors that have a lot of empty PR talk. And what you see a lot of is customer logos as proof. What we don't have are metrics. So I want to talk about those three topics very quickly: hallucination, privilege, and confidentiality, and benchmarks. So one thing to note about LLMs is that they are probabilistic by design. It's a feature, not a bug. And what that basically means is if you ask an LLM the same question twice, you're going to get slightly different answers each time. And that's just the nature of the beast. So as attorneys, where we are looking for deterministic work, very strict, structured output, how do you guard against this? And there's a couple ways. The first most obvious one is a very strict boundary of us, human in the loop. So a human checks it. Now, what you saw with the Simon Cromwell case is where some lawyers can't even be bothered to check a case citation. And I think that's aggravated even more so in the patent space, where you have claims where it's word by word, where every indentation, every comma, every apostrophe matters. And so I remember as a young prosecutor, had the two-finger rule, right? You had one finger on the claim that you're amending and one claim that was pending. And this was the sort of rigor that we were enforced as we were doing, as we prosecute. And today, with IDS hallucination and just how easy and convenient it is, I think there is some real pitfalls here when we allow LLMs to do all the work for us. And the issue gets even more aggravated when it comes to IDS or case citation. And I think the torpedo here is the Theracense rule, where your patent becomes unenforceable if there was some intent to deceive. So it's not hard to imagine a situation where a prosecutor submits an IDS, a hallucinated IDS reference. The question then becomes, does that rise to the level of intent to deceive? and then the explosive time bomb of your patent becoming unenforceable. Big issues with hallucination in LLMs. The second is privilege and confidentiality. So in this Hefner case that was recently decided last month, there was a client in a securities case, and the client had asked Claude some questions about strategy. Now, government, the opposing counsel government, wanted to pierce the veil there. And the judge ruled that it could because those communications between the client and Claude were not privileged. Number one, obviously, one point was that the LLM is not an attorney. It's not a licensed bar attorney. So there's no expectation of confidentiality. This is a point that I think is a huge trap for the unwary. So, for example, if you paste your client's invention disclosure into an LLM and it's a consumer model or it's even paid models, a free model, you could potentially have destroyed privilege in a future litigation. So let's say your patent gets litigated, opposing counsel can discover your communications with Claude where you're talking about the invention disclosure. And it gets even worse than that. Let's say your client decides and changes their mind and say, I want to make my invention disclosure a trade secret. Guess what? Pasting that invention disclosure just destroyed all trade secret rights to that invention disclosure. So this is a massive risk. Now, there are carve-outs for enterprise accounts, and you do need some safeguards around that. But I think this is a pitfall, and I wouldn't be surprised in 2 or 3 years if we see litigation that explores this very question. The final is benchmarks, and this is a pet peeve of mine. Even as a vendor, one of the reasons why I started Abigail is because I couldn't find the tools that I thought were sufficient. They didn't have the metrics that I was looking for. And what you found when you started asking vendors, how accurate is your tool? How well does it perform? And what you got is a lot of empty PR talk. You got a lot of marketing speak. They would have customer logos as proof, social proof. They would have demo videos as proof. They would refuse to publish. This is time and again, we've seen this repeat. And I think what's going on here is something very similar to what we saw with vendor security in 2010 when SaaS business models came out. So if a user asks, so what's your security on your platform? They would say, oh, trust us. It was all vibes based. Trust us. We're good to go. We've got the best security, etc. Then SOC 2 compliance came along, right? A strong benchmark, which people could ask the vendor and say, do you have SOC 2 compliance? So I think we're seeing the sort of evolution in the patent industry that we saw with security, which is you are going to see more standards and metrics that will be required in the industry. And so one of the things that I actually do, and I'm working with the European group right now, is I created something called Patent Bench. It's an ecosystem of various benchmarks that you can use to test and run your tool through. And there's various ones. And each one is available via NPM install. And so what I think is critical, in fact, it's table stakes at this point. You need to have metrics to understand, how well your tool performs. And this is the same thing that we saw with the SWE benchmark, software benchmark that Claude, Gemini, all these companies, OpenAI, which they now publish as part of every standard release. When they release the model, they give you the benchmarks. So 3 things: hallucination, privilege, and benchmarks. So I guess I could reserve questions until the end of the session. So now what I'll do is go and do a quick demo. So this is Abigail, and very cool things here. You can add your docket, and the strict boundary conditions that I've talked about is we put a lot of effort into making this deterministic, meaning that all the data that is ingested into the system and used is in a Postgres database, meaning that it is a deterministic, traditional relational database. There's no hallucination that can occur because it's basically a database read. And I think that's critical, especially when you're trying to look claim amendments, how they've evolved you know, over prosecution, absolutely critical. So first step here when you're trying it out is you would bulk upload a file of just basically all your applications, and you would import the cases. And at the back end, it will start processing each of the applications, download all the files, go through them, look at the claim amendments, and start putting them in a database. And this is, I would say, the 80% of the work. This is the critical portion of getting the data clean and getting it right. Once the data is in there, you can start asking it questions like, for your portfolio, like how many RCEs in my docket? And, it will give you answers because now it has all the information. So I have 37 RCEs across 30 applications. How many IDSs did I file? And this is actually very important because it gives you analytics. I don't know how many times where a client will ask me a question like this. What do we have coming up with maintenance fees? You have to look at pull a docket report, etc. This is the same thing, and it's the same structure. It's logical, it's deterministic, it's based on fact. Okay, so that's the docket. I can play around with that, have a lot of fun with it. The other is the forms. So if you want to create a form, you can create it manually. So let's say I want to create an RCE form. Click it here, and I can use this template and fill it all out, just like you would with other docketing systems. But the cool thing is also you can say create an RCE form for me here. Okay, so that's forms. And then of course we have a library. This is a vector database, and it's a library of all your cases, your prior art. And it's very cool because now you can cross-site. Let's say you have references in one case which are material, and of course you adjust the temperature on that, and then cross-site and very easily create an IDS form, generate the form, and then submit it in the USPTO office. So those are just the sort of administrative features. The thing that we're probably here for, which is the cool one, is actually drafting the response. And let's move to, okay, so this is a case page, for example, not a client, just picked it at random from the internet. And what you'll see here is that it processes the case page, can download the office action, the claims over here. It gives you a quick blurb of where you're at. You have 40 days, 49 days remaining, et cetera. And then it has examiner information. So it gives you the examiner profile. And as the AI creates a draft response, it will use some of this information. Okay, so this one looks like it was not parsed yet. And then you have your case details. This one good. And then for each section in your office action, it has parsed and gotten exactly the sections from your office actions. So it has the priority specification, your past response to arguments that the examiner. So this is basically a parse of the outstanding office action. And then you have the rejections. It has parsed through office action to get each of the different types of rejections. The one that we're probably here that's very interesting to us is the prior art. And so again, the rejection itself. So it goes out, gets the rejection, and then it parses through it. And then it also gets the cited sections from the prior art, because this is fed in as context when it generates a response. So here we have plum tree, and it goes out and gets the sections that was cited, paragraph 95, whatever it is, and creates the context intelligence layer for the next step. So next step is, okay, let's just jump right here to prosecution history. This is basically a download of the file history report on USPTO. So this is a single source of truth. And that's just for your convenience to look at. So you don't have to sign in, but what we're really here for is getting the response. So here we'll write the response. And so this is the claim that is as entered. I'm sorry, this is the claim that was just filed. And then this is the claim as it is entered by the examiner. So the examiner entered whatever amendment that you had here. And here's the amendment as it's pending currently. and which you'll be making amendments to. So you can make any changes here, whatever. So this is your workspace, and you also have your drawings, which you can draw, and you can also chat with your drawing. It will not draw new figures, of course, new matter rejection, but what it will do is it will handle specification objections. So, like for example, you're missing a lead line, you're missing a reference numeral. There's some minor specification objection. The AI will be able to handle it. And so let's say I want to draw a lead line from 120 to 130 here, you can write it in here and it'll do it for you. And then when you export it, it will export a copy of the replacement sheet and a copy of the clean copy, both of which are required when you submit drawing amendments. Okay, so let's start a new session here. So this is your workspace, and this is where you chat with your claims. So here's a quick summary of the non-final action, the rejections that you have, summary of your response, the objections, maybe even a double patenting if it's there. Now, very important step here. This is the review. This is the human in the loop step that I'm talking about. So this, again, this is a machine ingested parse of the data. And sometimes it can get it wrong, right? So for example, here I can already see, it doesn't have a space here after the and. So you might need to do things like that. And it's important that you do, this is the human in the loop step. Can't gloss over that because garbage in, garbage out. So let's say that we save that and now we mark the claims as reviewed. I'm not gonna actually go through all these claims. And it basically analyzes every section of the office action. We'll skip all that for now. And so here's our first substantive rejection. Rejection of claim 21 under 112A. So we're going to click on that. And what's happening in the background is the AI is taking the context from the office action, reading the claims, the prosecution history, and it's now going to also read your spec. So there's no new matter rejection. It's going to check your spec and make sure that there's support for whatever amendment you're going to make. And so here, let's see what it says. So here it says, amend claim 21 to clarify the configuration of the rotor head apertures as described in the specification. And it gives you the exact location where there's support for this amendment, the rotor head name. So let's click on that. And what it'll do is it will make the amendment directly to here. So here it's made the amendment to claim 18. And you'll have to hit save. This is very important because as you go through the rest of the rejections, let's say you made an amendment to the independent claim, whatever amendments that you make to independent claim must persist through the dependent claims or other. So let's say you have a system claim 1 and then a method claim 2. So I'll skip through this, not go through all the time. And then the last step, of course, is assembling the response. So you assemble the response here. There's a assemble response. And what it'll do is collect all your decisions, all your choices, everything that you've done so far, and it'll give you this workspace. So it's all the claims that you've done, all the arguments, you haven't made any here, and you'll be able to edit. So you can change whatever you want here. You can save it. And then finally, the last step is you export this document as a standard Word doc. So let's see. Okay. And so you may have to do some edits here, make some changes. Whatever amendments you made here will arrive and land on this document. So that's the entire life cycle of Abigail. It's focused on prosecutors and it's focused on those three issues: anti-hallucination, preserves privilege, and it has benchmarks. Final. So here I am looking for collaborators. Like I mentioned, I was working with a group in Europe. So we do have a GitHub. This is fully functional. You can download the white paper. And if you want to get involved in Patent Bench, where you could either be one of the judges or you can participate in this effort, please feel free to reach out to me. So we have all these various tasks that we're working on. We have some academia who's working on with us as well. And we hope to get this adopted as one of many standards in the industry. So with that, thank you, Alex.
Thank you, Roger. Maybe we have a Q&A session, and also like if you want to have a question to Roger, then you can use chat. So ask him, and then Roger will look at in the chat. And then maybe in the Q&A, maybe I'm curious about maybe other people is curious because you benchmark, right? So how about economic benchmark will be also very important, right? Because
Ah,
we really respect other tools and plus human, right? Especially you know that a lot of the patent work outsourced to the like a chief labor force like India and other area, right? Because that's a very long time, right? And then recently it is changes, right? So performance and then another thing rare. So economic benchmark will be also very important, right?
good point.
Yeah. Okay. And next, Alex, could you start?
Hi. So Alex Levin, Pioneer IP. I was listening to Roger. There are lots of very mutual points we share. In part, the start of the whole process for Pioneer IP. Necessity is the mother of invention. Laziness is probably the father. Uh, we started Pioneer IP because I am not as I have 20 years of experience of managing in patent portfolios on the in-house. Back in 2019, we had a case. One of my clients had a case where the business people who flew to a trade show brought back a suitcase filled with brochures, threw it at me, and told me, "Hey, look, Ian, there must be something because we have a patent portfolio, so there must be something." Okay, so we found this something and we started doing something. I'm trying to remain within the bounds of confidentiality here. And we ended up generating additional revenue by increasing the business for the client without going to court. So it wasn't a pure licensing negotiation, it was a business negotiation, and we ended up on friendly terms with the future potential clients. Once one of the negotiation points was IP license. I think for the in-house IP manager, that's the best outcome. Sitting on the client side, you don't want to go into litigation. You don't want to spend the management resource on litigation. You don't want to be at a position where your clients, instead of dealing with his own business, all of a sudden has to go through court proceedings and filings and brief and lawyers and lawyer fee, and it's just a sidetrack. So, but from another hand, developing an IP portfolio, working on prosecution, making all those inventions into granted patents with tools like Abigail has to have a purpose. And this purpose have to cater to the business needs of the assignee. Usually the business needs has to do something with the monetary value, either with valuation or with sale. So for the idea was to be able to optimize this process of finding a potential target and translate the legal case into a business case. And so this was the necessity part. The laziness part came in the fact that I never liked the idea of going and comparing each brochure to our patent portfolio. It was manual and tedious and laborious, and it wasn't fun. So we started to look into ways of automation of this process. It took us some years to arrive at something meaningful. And now, using statistical tools and using AI and machine learning, which is called AI now, we have something meaningful in hand, and this is Pioneer IP. Your point of hallucination in AI, I agree, it's extremely important. And I think the way you resolve it by going into certain databases and limiting the work of AI to certain databases is extremely important. And supporting every bit of what you do, making it documented, will ease of this inherited. It's not even a flaw of AI. Sometimes it's used as a feature. I think we see Charles Enderling here in the audience, and he just posted a Substack on a difference in answers when when the same question being asked multiple times. And that's, Roger, as you said, by nature of AI, this will be also will differ a bit. But we found a way to use this as a feature to our system, not as a bug, because every user is different, and every time every consecutive usage by the same user is different, and it teaches something the system about the user and about his needs and wants, and it allows the answer to be more adapted towards the usage, while the information that goes into the answer is limited to the same databases, right? So when it's supported. So then to the question of confidentiality, again, for us, it's easy because we sit down the stream from where Roger is. So we do not draft, we don't deal with confidential information. We deal with application or published patents and online search for online results that are published on the web. So everything we deal with is non-confidential. And then the question of benchmarking, as Roger said, I'm sorry, I'm at a terrible cold. And we're very lucky to have people like Charles reviewing us independently. So we're not like the basic LLM models who testify for themselves. We passed this test. No, we're lucky to have external reviewers who go and check us, and we're quite proud with our own results. But sorry, having said that, let me share my screen. Yeah. So, as I said, we're Parallel IP, and we deal with the question of infringement. Underneath everything we do is a patent infringement search where we take the claim and compare it to the web pages published on the open web. Be it whatever publication we can find, we will take it in a comparison. So it can be marketing websites, it can be tech documentations, it can be IFUs, it can be FDA, it can be standards, whatever it is, we can use it, we can analyze it, we can compare it to the claim that we are currently working on. Clearly, we start with the patent infringement search. That's the most obvious. So the input for us is patent number, and the user can provide us with additional knowledge. When it's additional knowledge, that means the user can target the search. Say, if I'm searching for Apple patents, maybe I want the search to highlight patents by Samsung, or vice versa. Maybe I want to search for compliance for a particular standard for SCPs, regulations, so other features, but we have the option for the user to steer the search in a certain direction. It means we still will cover everything we can reach, but we will highlight something in the results, because in what we believe, AI systems in the current state of development supposed to augment the patent practitioner. And we're much more into saving time of the practitioner rather than replacing it. So, for example, if we provide the system with a patent number and send it to search, we will see. we will see that the system will go and verify that the patent actually exists, not to repeat my own mistake here, the patent is active. And it also will ask me for what amount of independent claims I search. We can search for all the independent claims of the patent or the first claim only. We charge, as AI, we charge by tokens. Tokens are translated into credits. Each credit for us is a search for an independent claim. If a user wants to save on his usage, he may search for the first only as the broadest one usually, or search for everything. If we send the system to search now, it will take between 5 to 10 minutes for the search to complete. So we have this patent already open. The search was already done. The patent itself concerns surgical device. It's a surgical drill with expandable tools at the distal end of the drill. Fairly simple mechanical device. Okay. When it goes into a bone, the tooth is closed. When it comes back out of the bone, it flips the tooth open and expands the drilling bore on the way out. Fairly simple. Has two independent claims. Has a spec. The way we go about our searches is the system needs to read the claim, but then we do a Markov hearing to ourselves. So we try to construe the claim element, and in order to do so, we read the spec, but then we go and read every spec in citation, back, forward, and families, just to get better understanding of the claim elements. And then we go and read every spec in the classes. So whatever the examiner told us is relevant, we will read it and we will acknowledge it for better understand the claim element. With this understanding, we develop a string of online searches that bring back basically a huge pile of web pages. And then we need to analyze this huge pile. So we divide the pile into smaller batches where each batch will be relevant to a particular product by a particular company. Within this smaller batch, we choose the most relevant references. And based on those highly relevant references, we develop a product summary. So this product summary exists only within Pioneer IP. And then we use this product summary to compare to the claim. And develop a claim chart. In the claim chart, we will match the element to the product summary, mark it with a level of confidence to the match, and provide the reason for this mark, and provide evidence for this reason. Okay. So sometimes the claim chart that we developed looks like this. Some elements are matching with a medium level, some in high and some in low, and for some we were not able to find an evidence. Legally speaking, it's not the best case. Maybe there is something done after human review. There's not. But if we go to a different result, let's say here, and we look at this claim chart, we'll see that there is a high chance for every element. So maybe there is an infringement case. We do not provide legal opinion, but we want to augment the user and save the user's time and tell the user, hey, in what we found in under 10 minutes, maybe there is a case for you. The question becomes, okay, maybe there is a legal case and there is an actual infringement. What about the business? Remember, we said that for the in-house, the business is of utmost importance. So we go to the manufacturer and we build a BI report on the manufacturer itself of the accused device. We will see that the BI covers such questions as revenue size and headcount and jurisdiction, litigation history, portfolio of the accused companies that manufactures the accused device. Based on these findings, takes up to 2 minutes to build this report. Based on these findings, we will decide whether this case was pursuing. Maybe there is something for us, maybe not. Well, it works. Now we take the same logic and we apply it to portfolios. So now we can take a portfolio of a company and take a look at the whole portfolio, put targets there, see what we can do with it. For example, for the same assignee, Tag Medical, as the owner of the 750 patent, we just took random 5 patents by the same assignee and took a look at them. So for each one of the patents, we performed an infringement search. Now we can compare the patents one to the other based on potential to find an infringement case within each. And while we compare patents we can also compare the target companies. So now when we develop a licensing out strategy, we can prioritize business targets. Alteryx, which is $3 to $4 billion in 24, sitting in Southern District, US, is a certain target, right? Based on the legal case we filed. Maybe we want to start with Alteryx. Maybe we want to start with a smaller company. Maybe we have a working relationship with Alteryx. Maybe there's other considerations. But we know that within this portfolio, Alteryx appears in all 5 of the patents. We also know that within this portfolio, some of all products by Alteryx in their potential to find an infringement is this number. It's a meaningless number. It's meaningful only within our own setting because it allows to compare one to the other. So Alteryx has more potential than, for example, Convent, whatever it is. If we go to a target product, then again, in this view, we can compare products to products. So we use target products to compare legal cases. We use target companies to compare business cases. Okay. Talking about licensing out strategy. When you have a large patent portfolio, you don't necessarily want to deal with cases one by one. But remember where we started. The question is, when we prosecute, how can we make sure the prosecuted patent is not only patentable and granted by USPTO, but is also commercially meaningful for the patentee? This is why we built the Claim Optimizer. In the Claim Optimizer, we take a published application. It's important, it should be published. And we take the claim as the attorney is about to file after amendment. We treat it as granted. We perform the very same search as we done to the granted claim. And then we review the results and we see whether the amendment we've done is not only overcoming 102, 103, 112, but also provides commercial value to the client. So if we sync up published application, we know it's already granted, but we took it when it was an application. Claim 1 as initially filed in the initial phase. Let's assume I'm the patent manager of Xanadu Quantum Tech, and I want to make sure that I just received the notice of allowance. I want to make sure that the allowed claim is meaningful to the purpose of my company, to the IP strategy of my company. I will take this text, run it through Pioneer IP, and now I have to review the results. I see a single result that provides me a high probability of finding an infringement within. Okay, so I'm going in, I'm on the claim chart, and I see that maybe, it's important, maybe we're not providing legal advice and we're not providing legal opinion, maybe there is a case. But then going to review the commercial viability of this case, we see in MIT. Do we want to license out to university? It depends. I don't know. It depends on the IP strategy of the company. Then we go to the next one, which is a medium level result. And we see that the legal case here is not as strong as in the first case. But let's see who the applicant is. Sorry, the manufacturer. The manufacturer here is $16.8 million, 100 people strong French company. If the patentee sits in Europe, maybe it's a strong enough case. If a patentee sits in the US, 16.8 million in revenue, does it justify international litigation? I'm not sure. It depends on the company. Let's ask. But now we have the question to be asked. So the idea of Pioneer IP, again, is to review those cases, those options. And if be it the case that the management tells me, yes, we want to target a Quandela, we can now put extra work on the amendments in those two elements and try to amend it in such a way that it will both remain patentable using tools like Abigail, but also read on the Quandela product. So we can have targeted prosecution with an IP strategy in mind, strengthening the licensing out program of the patentee. For the practitioner, again, this is another usage that we've seen. For the practitioner, this tool changes the rates of continuation filings by his clients. Because imagine a scenario where the patent attorney for this assignee comes to him and tells him, hey, you know, your claim just got allowed. Do you want to file a continuation or not? The question will become, do we have a budget or not? But when the patent attorney on file comes to the patentee and tells him, hey, you know what? Your claim was allowed. This is the list of targets. Let's review it together. See if there is a commercial interest for you. See if you want to target someone from this list. See if it makes sense. Then the discussion becomes a discussion of strategy. Do I want to pursue this opportunity or not? If the company says we are much more defensive, excellent. Let's review whom of your competitors can you target with your IP portfolio in order to counterclaim should they come after you. There's the definition of defensive use of IP. So the whole idea of Pioneer IP is to make patent portfolios aligned with strategic goals of the patentees. Not only keep them patentable, but actually fit the business purposes. If anyone has questions.
Yeah, maybe we can have a Q&A session, and then also if you have a question, then use the chat. Okay, thank you, Alex. Okay, then could you sign out from SlideShare, then I can share mine. Okay. Okay. Okay, so I'm going to keep our schedule. So I'm going to finish up within 6 minutes, right? So I already shared this presentation. This is more than 60 pages, so it's impossible to share everything. but I will give the very, very important point, and actually that I share all of the, I think they optimize more than dozen white papers, the very, very detailed white papers supporting this, and then I have a several previous webinar to support this content. So, okay, so what I'm going to do is just to touch upon that half you to read and then basic point. Okay. Okay, so let me see. Okay. Okay, so what I'm going to talk about is the AI solution landscape and integrating AI across pattern workflow. So basically, I just summarize everything in a one page infographic. So what I'm going to talk about is to whole scope of AI supported, AI powered solution to in the exist to supporting whole workflow. That means the whole life cycle of pattern practice. So whole life cycle means that, as I mentioned, that we have two side of the two pillars already talked about by Roger and Alex. Was one is a patent prosecution and including the patent development, the innovation, invention harvesting, and then there is all the search related, and then interact with inventor, usually the disclosure, invention disclosure, and then drafting, preparing, filing, and office action, and then continuation, and many things like through the patent prosecution. And another thing is another layer is the as the Alex talked about is the patent dispute, patent enforcement, and patent litigation stage. And that there is a lot of the issues about the detail legally is needed and very detail about the claim charting require many things. And also another layer that actually that feel actually that I'm much more experienced than two other is patent monetization because I'm also like a licensed patent executive. So I'm a licensing executive professional. So I most of my in the IP space was actually the tie with some type of the monetization licensing and also like acquisition, M&A stuff. So I'm very familiar with that. And especially the standard SH pattern is my specialties. And then what I'm interested in is to what the available the solutions and how they integrate them into the actual practice and then have the best practice. What I mean, the AI native pattern practice. So then I as the because the current state of art the older solution is very modulated. I'm going to introduce one very compressed from the T by B. So they include many modules to, they have a specialties, right? Because whenever if you are the IB professional patent practice practitioner, and then you're depending on your task, you will do some part and then it'll be connected to other parts or something like that. So how to actually orchestrate, for example, you are the team like a leader of some your IP team in the in-house counsel or the law firm. And they do the same thing that AI, they call agentic AI orchestral layers do the similar function. And the most importantly, the human in the loop. And usually what I'm in my terminology I'm going is saying is kind of like a human and AI co-filer. So that layer integrate all the different layers of the pattern practice and then orchestrate and then they interconnected or something like that. That's my idea. So I'm not going to detail about the individual one, but as I said, I'm 30 years experience in technology innovation and also 20 years in IP space. So I know about both sides of what the solution working. Like Roger is the same side is a very deep dive into the his solution especially related to patent prosecution. I also same thing that I have experience all kind of like different layers of the different level how to implement AI. So I understand like the solution technical level understanding as I'm also a patent attorney and also like a licensed professionals. I know about the practicing patent practice and also kind of like IP licensing and many other monetization things. So I try to integrate whatever I experience as like a more systematic way to understand. So, solution landscape, because I'm just a skim over, like now that previously, for example, that my first involvement in IP was I was a straight advisor, big search firm. So they developing such tools and also developing the global IP, like a patent kind of like a database and something like that. Also like they doing, they call landscaping, all kind of such. So I have internally experienced what they're doing. And then now that the individual, this kind of tool now actually turn into the intelligence infrastructure, how you can integrate. So the core category AI solution is, the search intelligence. Usually, search means that the semantically traffic clustering, and then you know that there are many types of search depending on your pattern practice. Like one is most like important patternability, like prior search, whether you can be in the freedom of the operation, FOT. Also like infringement analysis and landscaping. There are many types, right? So you can utilize it and drafting, claiming, engineering support, and then patent prosecution, and then examiner modeling and portfolio governance, lifecycle intelligence, enforcement, monitoring intelligence. So I'm skipping over, so you can look at detail. How to integrate. So the problem is the issue is actually the workflow. You have a separate task, right? Is drafting the contact with the inventor and the invention harvesting, and also like a prior search and other search, and then drafting and then claim charting and for your claims, and then also like filing and interact with the PTO and also like examine review and the office section, many, blah, 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 right? But they are not completely kind of the like integrate every stage, right? Because that I want to be the holistic workflow. So still that the every workflow is not integrated fully. So I say like a fragmentation, and then I'm interested to how to integrate this workflow in a more unified way so you get the more kind of like a decision system type. So whenever they have it, and then actually they with completed system supporting the every aspect of your pattern practice. So continuous intelligence across life cycle is very important. So one intelligence module can be used in other intelligence. So you can have a systematic view. And then multi-agent orchestral layer that I actually develop. I'm very expertise in agentic AI, so I develop my own and then integrate the existing IP solution to them. And also one is kind of like so that's why that actually that I developed this agentic AI native pattern practice model, and then I'm trying to do like this is one of pilot that what is really needed in the kind of like ecosystem that the cultivating future AI native pattern practitioners or something like that. So it's a lifecycle integration decision system and continuous intelligence and feedback loop and human expert as a strategic calibrate as a AI as orchestral reasoning infrastructure. So I'm not going to tell about it. You look at this one. Actually, we had this talk 2 days ago with actually TYP professionals, but I have no choice. I showed this one, but I don't have any chance to go detail. But anyways, this is actually the existing commercial solution that I have a kind of like opportunity to explore the full module of the DYP. So DYP module is very comprehensive. All four types of the search is they have a module, separate module, and also like drafting and invention harvesting, and also like the OA and the continuation. So all prosecution layers there, review also there, And the portfolio like intelligence is very I experienced there. I like most of this is portfolio management. So I like this feature very well. So I use this one, and then I try to have some actual like a pattern practice in I just set the two cases for the in-house counsel in a view that, and one was a Perplexity is one of the Silicon Valley kind of unicorn that actually they are out of from Meta, Google. So they are looking for the next Google. So they are very, very advanced AI-based technology. So they are looking for the how to evolve their IP portfolio based on their previous one. They're increasing their business model innovation. So in that, have in mind that and said I have developed scenario that actually integrate deep IP module to actually practical way to actually you perform this one, and then you can scale. OpenAI is the same thing that is a unicorn, and then it's actually the more than unicorn actually. And then I analyze 100 their patent portfolio, and then look at every aspect of how they actually the patent strategy and the integrated workflow. So I just to give you very detail in here. So and then my goal actually to do actually you can explore this kind of tool and actually that like learn your scenario actual pattern practice, and then you can experience. That's my goal. So I really want to have this kind of hands-on implementation that and I want to explore any kind of AI solution that I have expertise and utilizing them, and then integrate with any practical workflow. And then I want to let other people to explore this kind of like capabilities to they implement it in-house, whether it's in-house counsel or whether you're the like a law firm or other business purpose, right? This is my goal. Okay, so finally, next my topic with the identity legal knowledge management. So if you're interested, then you can attend. And another one is I'm going to be in IPBC. So there will be I'm going to organizing the AI native IP professional gathering in San Diego. Okay, so I hope to see you there. Okay, and then finally, only 4 minutes left. But anyway, because if you have any question or other thing, or you want to share your comment, probably Charles. I know that you're very expertise a benchmark, especially for the like a patent enforcement, patent litigation area. So could you share if you have it, any insight about that? Yeah.
Well, yeah, certainly. I've been focusing on infringement detection, although I've started looking at drafting tools. I'm going to publish something on that, but you're way ahead of me. I don't do any work on the prosecution side, but on the infringement detection side, the tools are quite impressive. I mean, they're not hallucinating. They're frequently converging. I would say we're starting to see issues where you use different tools and you get different answers, but it's also very correlated with the patents being either infringement is not very observable, or maybe the patents aren't very good. It occurred to me today as I was looking through, all that's transpired, is that the statistics on patents isn't going to change in terms of infringement. It used to be, my mentor taught me that only about 3% of the patents in a portfolio are any good. So if you have an industrial portfolio of 500 patents, don't expect more than 3% to be infringed and enforceable. And AI is not changing that, but I think the tools are causing us to hallucinate a little bit into thinking there's more better patents than there are. So I'm quite impressed with the tools. There's a lot of work to do, but it's short-circuited weeks and months of work. So that side's really great. And I have high hopes for the prosecution side. A lot of questions, and the one I put out there was like, what about 101? There's something that we humans don't understand because it's the mess that we made. So thank you for all of this great work and a great presentation.
Oh, thank you. Yeah, probably Roger, you maybe share with the 101. I also have a lot of experience with the 101. And also I test a lot of the tool. Whenever I test tool, I test the 101. It's very, very abstraction layer, right? Because 102 or 103, 112, very, very specific. Right, so they're following some specific rule, right? So, but 101 is very abstract, right? For example, my experience 101 is that because same claim, similar one is accepted by examiner, one is not, right? Because even examiners following MPP or whatever, but because they are very abstract, right? Because there should be more than abstract, right? Because the determination whether it's not against like one-on-one, it's a more than that, or is kind of like unexpected innovation or something like that.
Well,
But
it's very squishy. It's squishy and it's wrapped in with 103 now. It's a big mess. So what are you say you use the tools to test it? Do they help at all? I mean, the most I can see a tool doing is laying out what it sees as facts, but I don't see how the tool's going to do any meaningful rating on one-on-one risk in litigation, or how to overcome a one-on-one in prosecution. Could it even advise you?
No, because that's the problem actually the Roger mentioned, right? Because the tools are not actually the human line, right? For example, that I just test my own like a previous issued patent, right? And then usually that my experience, right? Because maybe not others, right? Because usually the claim is determined by my interview with the examiner rather than I just like officially kind of like rigorously expect, oh, okay, so this rejection, okay, so I have like amend something or something like that. So we practice as a patent lawyer, but usually the end of thing is through the negotiation with the examiner. So claims are completely the final claims are completely not actually within the boundary of the AI expected or other patent practices expected, right? In some area, right? So maybe Roger, you are the best one. So he's more focused on patent friction than me. So
I think there's good news. The pendulum has shifted, right? We have Squire, who has signaled that AI inventions are patentable. There has been a lot of uh, published opinions on that point. And so I think, back in the Mayo days, Alice CLS, I remember going through all of that and us patent attorneys having some great fun conversations at every conference about 101. But I think it has actually shifted to a point where, and this is where good practitioners and claim drafting is critical. It can't be a generic use. You have to tie it to something. I see that in my practice all the time. And so how you draft the claims, there is definitely a push towards getting AI inventions. I think an interesting question to this is how the patent office will implement AI in their own prosecution. So we saw a couple initiatives. I think there was the April Fool's joke with Squire where he was talking about AI taking over. It's already implemented. And you have comments in industry, Elon Musk saying, patent system is cooked. Why even need a patent system? And the hot take is if you have AI and it can come up with inventions and design around you in 1 minute or 2 minutes, what's the point of the patent system? And I think what they miss is that the patent system is the best training set that was ever invented. The public disclosure helps build on the shoulders of giants. And what we need is not throwing out the baby with the bathwater. We need to improve our patent system. And probably what that means is two things: making it more efficient and making it faster. And I think Squire is doing that, laying the framework for AI intelligence and AI patents, and bringing the system into this new paradigm that we have. And those are interesting topics. I'd love to explore that further perhaps in another session.
Roger, actually, could you share briefly about the economic model? Like, briefly, yeah.
Sure. So I've been involved in M&A, Fortune 500, and patent evaluation is one of those sticklers, right? You got the cost model, you've got the market model, you got the licensing model. You got 3 models for patent valuation, and everyone has a lot of fun with that. They go back and forth. I think from the prosecution side, the questions, executives look at patents as a cost center. They say,
Yeah.
hey, look, it's just a drain on my budget. What are you delivering? What kind of value am I getting out of this? And we like to say, okay, this is how many months to allowance. This is your potential revenue that you can get. This protects the franchise here and there. And they're always looking for clear economic benefit. And I think the industry has struggled with that for quite a bit. And so we have like these broad brush strokes, what do other people pay, right? What's the fair market value? How much did it cost me to even get this? And so these are kind of hand wavy approaches, and then the industry sort of settles on. And I've been a member of LES and LESI for many years, and I remember in the biomedical space and pharma and combination products that was so always been a topic. What is the value of these patents? And I think AI, with Alex's tool and his approach to being the rigor that's involved, any in-house counsel you ask, they're less focused on the prosecution side. They're actually having to kick up to the executives and say, okay, what's the value here? What am I doing? And so that's what they're focused on. I think he's addressing a critical need in that space. And so with the tools, I think eventually with the help of Alex and what they're trying to do, and Charles as well, we will get to a benchmark that has a dollar value attached. And I think a part of that will be LLMs as judges. We'll probably need a multimodal world model that takes in all the various inputs. I hate to throw out the word agentic, but it will probably have to go out there and do a lot of competitive research. And we might, eventually settle on a good layer. And that kind of topic, I think, would be very interesting to pursue academically and, as an enterprise doing.
Oh, thank you. Maybe we don't have a time, but actually, if we have more time, actually, I have a lot of the discussion with Alex because of I also like involved the litigation side, and I understand your layer it's kind of like initial state of screening, and then more like a business side rather than legal side. So, yeah, because if you go deep into the like legal side is a huge thing, especially economy model, right? For example, that if you have like a legal opinion about the litigation, then I don't have much experience, but I have some of the law firm experience, and that law firm actually my lawyer is to involve all the like early stage in like due diligence about the litigation. Then usually that how much the charge per hour for the litigation attorney,
Yeah.
right? Right?
Yeah.
Is it, like so usually for example my experience of law firm is that because of the revenue stream by the three pillar, right? Patent protection part, huge numbers associated required, but less revenue. Right? They need like a huge like a contract with the in-house counsel. In the litigation part, very lucrative, right? Because one case like more than 1 million, right? Usually the partner's rate is $1,000 per the hour. Usually the associate at least like $500 hour, right? Huge amount of revenue generate, right? So that side of it, the very if you go to the more deeper, right, and then economic model is very like whether you can be like do like for example like a Markman hearing type like a due diligence, claim tracking or whatever, right? So that may be the very exciting side whether any kind of like tools actually that go deeper into that area, right? And then that will be the very like interesting things. To me, there are many topics I want like sure. Okay. Anyway, so could you share your final insight? So before we.
Just to support what you said, I'm trying to combine what everybody on the panel brought up. So Charles said we have 3% of working patents within each portfolio. Roger, you referred to the way of prosecuting things in a meaningful way for the later stages. Alex, you referred to the later stages as a litigation tool. Just imagine yourself when all of us together, drafting tools, litigation finding tools, IPMSs for whatever they are, we will be able to in some way develop patents where each patent will be not within those 3% of working patents actually making it 100% of the new patent, right? So effective prosecution with a future possible litigation in mind, to my opinion, and to the view of Pioneer IP, and I guess to the view of other tools in the infringement space, effective prosecution, this is what yields such a patent. And this is what makes the companies, the patentees, see not the patents not as a cost center anymore, but as a strategic asset which is patent initially was designed to be. Right. So this is to say, let's play together. It wouldn't be a kumbaya, but it will address lots of questions currently addressed by the patent owners to the patent practitioners.
Okay, thank you very much. Okay, so thank you, Roger and Alex, to share your great insight today. And then to any other people, actually the Charles, to share your insight, and then other people to attend. Okay, so I hope to see you again in my another webinar, or if you are going to participate in the IPPC, then we can see in person in San Diego. Right? Okay, so thank you and have a nice day. Take care. Bye-bye.
Thanks a lot.
Thank you.